agencies, otherwise known as CRAs. September 7th, 2017 changed our data security landscape forever. That was the day that Equifax announced that it had exposed the Social Security numbers and other sensitive information of nearly half of all Americans. Specifically, 148 million Americans had their sensitive information exposed. That event educated many people for the first time about CRAs and the huge amounts of sensitive information that they hold. What people still may not know is how many more of these companies exist in America. The Consumer Financial Protection Bureau, or CFPB, estimates that there are more than 400 CRAs today. Criminals want access to the treasure troves of data that CRAs hold. They want that information so they can open fraudulent accounts and run up debt in the names of innocent people. In studying this issue, I was deeply saddened to learn about one Illinois resident whose credit was so badly damaged by identity theft resulting from the Equifax breach that the person was denied both employment and housing. This is but one example illustrating the extreme and decades-lasting implications of allowing people's Social Security numbers, birth dates, addresses, driver's license numbers, and credit card information to be exposed to cyber criminals. And again, I want to let this sink in. This one particular breach with regard to Equifax has the potential to cause extreme harm to nearly half of the population, or 148 million Americans. A year and a half has passed since the Equifax breach, and the causes of that breach have been investigated and exposed. Moving forward, it's our job in Congress to help prevent future data breaches and to prevent more Americans from having their sensitive personal information compromised. Through the Graham-Leach-Bliley Act, otherwise known as GLBA, Congress directed the Federal Trade Commission to implement data security rules for CRAs. To achieve that, it created the quote-unquote safeguards rule, which requires CRAs to take quote-unquote reasonable steps to protect consumer data. But the FTC has limited recourse against a CRA that violates the safeguards rule. It cannot seek penalties for first violations, and the FTC can only seek monetary compensation for consumers if they have identified a specific harm. Because the negative effects of a breach can often take years to surface, it is extremely difficult to reduce this harm to a single dollar amount. CRAs also hold huge sway over the lives of consumers. The information they control could determine if someone gets a loan, a job, insurance, or a home. Yet, CRAs are not accountable to those same individuals. If consumers dislike a CRA, they cannot hold them accountable by taking their business elsewhere. But Congress can and should hold CRAs accountable by giving federal watchdogs the tools they need to make CRAs care more about data security. Failure to implement proper data security must cost CRAs more than investing in good security to prevent a breach. That is why today, Senator Elizabeth Warren and Chairman Elijah Cummings released a proprietary report by the Government Accountability Office, the GAO, which we will closely examine in this hearing. In this new report, GAO has recommended giving the FTC penalty authority for first violations to prevent breaches and to protect data security. This is a nonpartisan analysis, and in fact, Democratic and Republican FTC chairmen have called for increased penalty authority for first-time violations, including the current FTC chairman, Mr. Joseph Simons. Enhancing FTC penalty power to enforce data security follows the model set by regulations in the banking industry. There, so far, knock on wood, we have avoided the types of large, harmful data breaches that brought us here today. Simply put, GAO does not think that the current regulatory system is strong enough to get CRAs to improve their data security. So far, many CRAs have been able to internalize the profit off of consumer data, externalize the risk, and leave consumers holding the bag. Today's hearing is the first step in ensuring the data of American consumers is being properly protected. Now, with that, I'd like to recognize our distinguished ranking member, or Mrs. Miller sitting in for the ranking member. You have 5 minutes.
Thank you, Mr. Chairman. I do not have an opening statement, but I do want to thank you all, you witnesses, for appearing here today, and I looked forward to your testimony and our discussion. I also have the prepared remarks of Ranking Member Cloud, and I ask unanimous consent that they be inserted in the record.
Without objection, so entered.
Thank you, Mr. Chairman, and I yield back.
Thank you, Mrs. Miller. Today we are joined by Mr. Andrew Smith, the Director of the Bureau of Consumer Protection of the Federal Trade Commission, Mr. Michael Clements, the Director of Financial Markets and Community Investment at the GAO, as well as Mike Litt, the Consumer Campaigns Director at U.S. Public Interest Research Group. And finally, Jennifer Huddleston, a research fellow at the Mercatus Center. If the witnesses would please rise, I will begin by swearing you in. If you could put up your right hand, please. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Could you speak up a little louder? Thank you. Let the record show that the witnesses answered in the affirmative. Thank you, and please be seated. The microphones are sensitive, so please speak directly into them. Without objection, your written statements will be made part of the record. I should tell you about the lighting system. I told a couple of you, but green means go, red means stop. Yellow is different than what we see at stoplights. Here you have to speed up, not slow down. So with that, why don't we begin with Director Clements. You are now recognized to give an oral presentation of your testimony.
Chairman Krishnamurthy, Representative Miller, and members of the subcommittee. I am pleased to be here today to discuss our recent report addressing oversight of consumer reporting agencies, or CRAs. Our bottom line message: actions are needed to strengthen oversight of CRAs. CRAs serve an essential function in the financial services industry. These companies collect large amounts of sensitive information about consumers. These companies maintain and analyze that information and ultimately package the information into consumer reports. These reports help determine whether and how much consumers pay for credit, and can also be used in employment and rental decisions, among other purposes. At the same time, consumers have limited choice in the CRA marketplace. Unlike many other products and services, consumers can't exercise choice if they are dissatisfied with a CRA. Further, consumers don't have the legal right to delete their records with a CRA. CFPB and FTC have noted the level of consumer protection required can depend upon consumers exercising choice in the marketplace. Less choice implies the need for greater oversight. The 2017 cyber attack on Equifax, with the theft of at least 145 million consumers' records, has focused attention on oversight of CRAs. With this context, I'll focus on FTC's and CFPB's oversight of data security in the CRA marketplace. First, FTC. FTC enforces CRA compliance with the FTC Act and the Gramm-Leach-Bliley Act, or GLEBA, among others. Section 5 of the FTC Act authorizes FTC to investigate and take enforcement action against companies that engage in unfair or deceptive practices, including those related to data protection. FTC has taken action against 66 companies, including CRAs, under Section 5 for unfair or deceptive practices related to data protection. GLEBA seeks to ensure that financial institutions protect consumers' non-public information. As required by GLEBA, FTC adopted its safeguards rules. Among other things, the safeguard rule requires that financial institutions assess the risk to consumer information and have a plan to mitigate those risks. FTC can enforce the safeguards rule through injunction, redress, and disgorgement. However, assessing monetary harm can be difficult with data breaches because, for example, the resulting harm may occur years in the future. Thus, we recommend that Congress consider granting FTC civil money penalty authority for violations of GLEBA. This would give FTCs the tools to carry out the enforcement authority that Congress has already provided to FTC. Second, CFPB. CFPB enforces and examines CRA compliance with several consumer protection laws, including the Dodd-Frank Act and portions of GLEBA. Under the Dodd-Frank Act, CFPB supervises larger market participant CRAs, those with more than $7 million in annual receipts from consumer reporting. However, we found that CFPB does not have a good handle on the number of CRAs that meet its larger market participant threshold. Thus, we recommended that CFPB identify additional sources of information that would help ensure that it's tracking all CRAs that meet its threshold. From 2015 through 2017, CFPB examined several CRAs. However, we found that its prioritizing process does not routinely account for data security risk. To determine specific areas of compliance to assess, CFPB considers sources such as consumer complaints and past exam findings. While important, these sources don't consider how an institution would detect and respond to cyber threats. Following the Equifax cyber attack, CFPB initiated data security exams of the major CRAs, but it's unclear whether and how CFPB would incorporate data securities into its prioritization process going forward. Thus, we recommended that CFPB assess whether its process for prioritizing CRA examinations sufficiently incorporates data security risks that CRAs pose to consumers' information. Chairman Krishnamurthy, Ranking Member Miller, and members of the subcommittee, this completes my prepared statement. I would be pleased to respond to any questions you may have.
Thank you very much, Mr. Clements. Mr. Smith, please.
Thank you, Chairman Krishnamurthy. Mr. Chairman and members of the subcommittee, I'm Andrew Smith. I'm the Director of the Bureau of Consumer Protection at the Federal Trade Commission. I appreciate the opportunity to appear before you here today to discuss cybersecurity at the consumer reporting agencies. I also want to thank Mr. Clement and the GAO for its recently issued recommendations to improve the tools available to the FTC to enforce the data security laws applicable to consumer reporting agencies. My written statement represents the views of the Commission. This opening statement represents my views alone and not necessarily the views of the Commission or of any individual commissioner. To promote the security of consumers' personal information, including information at the credit bureaus, the FTC focuses on three main areas. The first of these is enforcement. For nearly 2 decades, the FTC has been the nation's leading data security enforcement agency. We're charged with enforcing data security requirements contained in specific laws, such as the Fair Credit Reporting Act and the Gramm-Leach-Bliley Act. We also enforce Section 5 of the FTC Act, which prohibits unfair or deceptive practices, including unfair or deceptive practices with respect to data security. In this law enforcement role, the Commission has settled or litigated more than 60 actions against businesses that allegedly fail to take reasonable precautions to protect consumers' personal information. In 2017, the Commission took the unusual step of publicly confirming its investigation of Equifax and the Equifax data breach due to the scale of public interest in the matter. Our second area of focus is policymaking. The FTC has conducted workshops, issued reports, and made rules to promote data security. For example, just earlier this month, we announced a notice of proposed rulemaking to update our safeguards rule under the Gramm-Leach-Bliley Act. The safeguards rule was originally issued in 2002. It requires financial institutions within the FTC's jurisdiction, including credit bureaus, to implement reasonable process-based safeguards to protect personal information. The proposed revisions to the safeguards rule are based on our nearly 20 years of enforcement experience. These revisions are intended to retain the process-based approach of the safeguards rule, but to provide financial institutions with more certainty regarding the FTC's expectations with respect to data security. Our third area of focus is education. The Commission has issued numerous guidance documents for businesses, including written materials, blog posts, and a comprehensive small business cyber education campaign, which includes how-to videos and training materials. These materials distill lessons learned from our enforcement actions in a succinct and accessible manner. With respect to cybersecurity at credit bureaus, the education of consumers is also critically important. Following the Equifax breach in September 2017, we established a dedicated web page for victims of the breach. And during that first month, the FTC blog on the Equifax breach reached the most viewed government web page nationwide, surpassing pages for disaster assistance after major hurricanes. The FTC's Credit Freeze FAQs article and IdentityTheft.gov recovery steps also made the top 5 most viewed government web pages in September of 2017. We vigorously use our existing authority to protect consumers, but we need additional tools. In this regard, we appreciate and agree with GAO's recommendation to give the FTC civil penalty authority for violations of the Safeguards Rule. In fact, however, we have called more broadly on Congress to enact comprehensive data security legislation that includes rulemaking, civil penalty authority, and enhanced jurisdiction for the FTC. First, the legislation should authorize the FTC to issue data security rules under the Administrative Procedures Act so that we can keep up with business and technological changes. Where we currently have rulemaking authority, we've used it, as demonstrated by the proposed revisions to the Safeguards Rule, which I just mentioned. Second, the legislation should allow the FTC to obtain civil penalties for data security violations. Currently, we have authority to seek civil penalties for data security violations under the Children's Online Privacy Protection Act and the Fair Credit Reporting Act, and we've used it. To help ensure effective deterrence, we urge Congress to enact legislation to allow the FTC to seek civil penalties for data security violations in appropriate circumstances. Now, finally, the legislation should extend the FTC's jurisdiction over data security to nonprofits and common carriers. Entities in these sectors often collect sensitive consumer information, and significant breaches have been reported, particularly in the nonprofit, educational, and hospital sectors. Thank you for the opportunity to appear before you, and I look forward to answering your questions.
Thank you, Mr. Smith. Mr. Litt, you have 5 minutes. Sorry about that.
Take 2. All right, good afternoon. Again, my name is Mike Litt with US PIRG. I appreciate the opportunity to testify before you today. In order to improve data security at credit reporting agencies, also known as credit bureaus, we need robust financial penalties, stronger oversight, and better consumer control of our data. You mentioned the Equifax breach. All we have to do is look at that to see the real dangers that are posed to real people when credit reporting agencies drop the ball on their data security and lose our data. I'm one of the 148 million Americans whose financial DNA was exposed, and we are put at risk of identity theft and all sorts of fraud for the rest of our lives. Equifax still has not paid a penalty after putting people in harm's way. And we have no choice over Equifax or the other credit bureaus. Can collect our information and sell it, and when they lose it, we can't leave them the way we can other companies. And it's exactly that dynamic why it's important that we have robust financial penalties when data is lost and strong oversight to prevent data loss in the first place. If you're a larger credit bureau and you don't comply with the Federal Trade Commission's Safeguards Rule, there should be mandatory penalties. If you lose personal data, there should be mandatory fines. But at the very least, we need to make sure that the FTC can actually issue penalties for the first violation of the law. They're investigating the Equifax breach, but they'll only be able to issue a consent order, and then only if Equifax breaks that order and then violates the law a second time can there actually be any fines. We need to change that. Next, I'd like to discuss some ideas for oversight from my written testimony. The Consumer Financial Protection Bureau does have tools that the FTC does not. It can issue civil penalties after first violation of the law. It can examine companies to catch problems ahead of time. We know from Equifax's SEC filing last month that the CFPB has been investigating the Equifax breach, and they have expressed their intent to actually issue civil penalties. So clearly the CFPB is using its authority to take action on data security. We'd like to see them consider and prioritize data security for examinations of other companies as well. The Oversight Committee's report on the Equifax breach that came out in December shows that hackers exploited unencrypted info and weak data controls. The FTC just proposed an amendment to its safeguards rule that would require some good first steps for security measures, such as data encryption and multi-factor authentication and data controls. Finally, I'd like to talk about better consumer control over our own data. The best way to stop an identity thief from opening new accounts in your name is to get credit freezes, also known as security freezes, at all 3 of the national credit bureaus. Basically, a credit freeze blocks or freezes access to your credit reports. Before the Equifax breach, the credit bureaus charged fees for freezes in most of the states. After the breach, 19 states made freezes free. Congress followed suit, passed a law that eliminated fees for everybody. In my written testimony, I explained problems with the national freeze that we would like to see fixed, and we've got some other ideas in there for better consumer control. But really, the best solution would be to make sure that access to our own credit reports is actually frozen automatically by default. We shouldn't have to opt in to control access to our own data. So to summarize all of this, we are not the customers of the credit bureaus, but the credit reporting agencies possess vast amounts of our personal information, including our financial DNA. And that is really why we need to be able to have robust financial penalties and strong oversight to incentivize them to protect our data. The FTC and the CFPB should use their authorities and be granted expanded authorities in order to achieve those goals. And additionally, we should be given more control over our own personal data. I look forward to working with you, and thank you so much.
Thank you, Mr. Litt. Ms. Huddleston, you have 5 minutes.
Thank you. Good afternoon, Chairman Krishnamurthy, Representative Miller, and distinguished members of the Economic and Consumer Policy Subcommittee. My name is Jennifer Huddleston, and I am a research fellow with the Mercatus Center at George Mason University. My research focuses primarily on the intersection of law and technology, including the important issues surrounding data security and data privacy. Thank you for the opportunity to discuss some of these issues today, particularly in regards to the 2017 Equifax breach. These conversations are particularly important as we continue to see headlines around data breaches and data privacy. As policymakers consider how to address such concerns, they should be careful to avoid unintended consequences to innovation as a result. With this in mind, I would like to focus on 3 key points today. First, that regulators should avoid an overly expansive definition of harm in their approach to data security to avoid unintended consequences to innovation. Second, the way the FTC's current enforcement approach has provided a balanced approach to data security and data privacy, allowing innovation to flourish and providing consumers a form of redress. And finally, with regards to credit reporting agencies, that policy solutions should be narrowly tailored and focused on the unique position of these agencies and the data they possess so as to avoid or limit unintended consequences to broader database industries. To begin, regulators should be cautious about an overly expansive definition of harm in their approach to data security that could have unintended consequences to innovation. While there is general agreement that data breaches have the potential for harm, there is disagreement on when harm occurs, the need for government intervention, and what particularly constitutes harm in these scenarios. There's a wide range of personal preferences and what information we choose to share publicly or privately through various data systems, and a flexible system provides options for both consumers and businesses and encourages innovative solutions when it comes to data security. While it is easy to rush to the worst conclusions when we see scary headlines and hear news of breaches such as Equifax, only focusing on the bad could prevent future innovation that would provide better alternatives and better data security more generally. A lack of flexibility in a rigid system could lock in existing options rather than providing incentives to innovate and provide better data security more generally. Now I would like to turn to the general success of the FTC's current enforcement approach with regards to balancing innovation and redress for consumer harm. The FTC has been active in both personal data and credit reporting and financial privacy. It has addressed data breaches under both deception and unfairness doctrines, as well as other laws when specified. But in general, it has built a common law of consent decrees rather than more formal regulation and adjudication. While this allows for greater flexibility as innovation evolves, it also can raise concerns due to lack of clarity and certainty for regulated parties. At the same time, though, this approach has allowed consumers benefits of a data-driven economy while still providing redress when consumer harm occurs. Finally, with regards to the unique situation of credit reporting agencies, the policy solutions in this regard should be narrowly tailored so as to avoid unintended consequences to database industries more generally. The credit reporting agencies are in a unique situation in that there is no opt-in or opt-out for consumers. Additionally, due to high barriers to entry, there may be less concern about potential impact on competition that such regulation could have. Given these factors, the policy solutions to address these concerns with regards to data breaches and data security should focus on these unique aspects and the data that is uniquely concerning when it comes to these agencies. At the same time, though, we should also consider what, in addition to regulation, or as an alternative to regulation, might be done more generally. For example, consumer education and empowerment, including increased transparency so that consumers are aware of what to do in the event of data breaches and what resources are available to them, as well as common law alternatives for those that have experienced harm and accountability for those who caused it. The U.S. has been a leader in innovation, and this makes it especially important to carefully consider the potential for unintended consequences and not prevent potentially innovative solutions that would provide better data security in the future. Thank you, and I welcome your questions.
Thank you, Ms. Huddleston. First of all, thank you to all of you for joining us today, all the witnesses and, of course, the members of the audience. I want to start with Mr. Litt. I recognize myself for 5 minutes of questions. You know, Equifax had very sensitive information about at least 148 million people, their names, social security numbers, addresses, dates of birth, and so on. Do the other CRAs have similar information about as many consumers?
Yeah, in fact, it's probably more. The CFPB has said that each of the credit bureaus possess approximately 200 million different consumer files.
And I mentioned some types of personal information. Are there other types of sensitive information that they possess?
Well, they have information that's in our credit files that could show whether you're in debt or debt collection, your credit history. Also, credit bureaus have investigative reports on some consumers. So these are basically background checks that can include interviews with your coworkers, your neighbors, your friends and family, other people in your life.
Do you have any indication that CRAs are collecting less information today than they were at the time of the Equifax breach?
No, I have absolutely no indication of that.
Can you explain a couple of the more serious risks that consumers face when their sensitive data is exposed?
Yeah, so in the case of the Equifax breach, where you have just your name and your social security number, an identity thief can try to apply for a utilities account, credit, a loan, get a smartphone on your account. Then they can use your date of birth, and they can try to apply for your social security benefits, your tax refund that you might be counting on, your medical services and benefits.
Okay. Without objection, I'd like to enter into the record a complaint submitted to the Consumer Financial Protection Bureau by an Illinois parent who was a victim of the Equifax data breach. This was the complaint, and you know, I read a portion of this earlier, or read about it earlier, but basically this person was unable to receive housing or employment because of the harm from the data breach. Director Smith, I have a question for you. With their high concentration of sensitive information, are CRAs subject to constant attack by cyber criminals? What's the nature of the attacks and the threats posed by cyber criminals?
So that's probably a better question for the credit bureaus, but you know, our understanding is that financial institutions generally and credit bureaus specifically are subject to constant attack given the value of the information that they warehouse. And I think what you would find is if you spoke with financial institutions, they would say that they are under constant attack. And that's one of the issues for us at the FTC, is that we want to make sure that financial institutions are always monitoring for penetration and intrusion, and so that the breaches are actually being detected, because that's one of my real fears, is that there are breaches that are going undetected.
Well, that's what I was going to ask you next. Equifax may have garnered the most attention, but you know, can you talk about other data breaches at any other CRAs in recent years?
Well, we've brought some enforcement actions in connection with data breaches at consumer reporting agencies. The most prominent is probably our action against ChoicePoint several years ago, where they were selling credit reports to a ring of known identity thieves. And there we sought, well, we obtained $10 million in penalties and $5 million in consumer redress. I will say that most of the cases that of the 66 cases that Mr. Clement mentioned in the data security area, a couple have involved credit bureaus, but mostly not. It's mostly other types of companies, primarily operating online.
Got it. Mr. Clements, can I ask you the next question? Can you identify other, you know, regulatory areas where, you know, the penalty for a first violation has been found to be effective, or, you know, what's the nature of the impact of such a type of penalty?
We do know in the banking space that the federal banking regulators, so that would be, for example, Office of Comptroller of the Currency, the Federal Reserve, and FDIC, do have civil penalty authority under GLIBA for those type of violations. They are also examining these institutions on a regular basis. If it's a larger institution, it's subject to continuous reviews. If it would be a smaller institution, every 12 to 18 months, there would be an examination.
Got it. I am out of time. I'm going to recognize Mrs. Miller for the next set of questions.
Thank you, Mr. Chairman. Ms. Huddleston, in your testimony, you state that the Federal Trade Commission's current approach has been flexible and therefore has allowed innovation to flourish while still protecting consumers. Can you please expand upon that?
Thank you, Mrs. Miller. I would point to the fact that the Federal Trade Commission has been active in data breaches and data privacy going back to the late 1990s with GeoCities. Our data security and our innovation when it comes to online websites and what we expect them to protect has come a long way. And part of this has been, rather than having a ex-ante approach of regulation, they've been able to provide a flexible guidance that allows different methods to develop to better protect consumers.
Thank you. While it may sometimes be a useful tool, enforcement actions by federal agencies should not be the only way to ensure consumer data is safe. Would you agree?
One of the interesting elements with enforcement actions is how once they are enacted, they can be unflexible and unmoving. This can affect both consumers and companies that are subject to consent decrees. At the same time, there are also already existing tools, including the common law for consumers who may have a direct proof of harm for something like identity theft. There can also be criminal issues involved depending on the nature of what has happened as a result of the breach.
What are the pitfalls of excessive government intervention in a rapidly evolving area like information technology?
We have benefited a lot from innovation, and many of us have seen how rapidly in our lifetimes things have changed as a result of allowing innovation to accelerate. If we have a lot of regulation in a rapidly changing area such as data security, it's possible we may lock in the existing system rather than getting a better system that could protect our data more.
What are some buffers that could be created to narrowly tailor regulatory authority?
When considering what to do with regards to the credit reporting agencies such as Equifax and these concerns, I would suggest that we look very carefully at how we're defining data and how we're defining what entities are covered so that we're truly addressing those concerns.
What can the Federal Trade Commission do to provide greater education to consumers?
I think that in light of the Equifax breach, what we've seen is a lot of consumers really want to get interested in how they can protect themselves and take those steps. As we heard mentioned in earlier testimony, immediately after the Equifax breach, the blog post on what to do was one of the most visited government websites. Continuing to provide that information to consumers, be it through websites or through other educational campaigns, so that consumers can then take the appropriate next steps themselves.
Thank you. We have heard a lot recently about the General Data Privacy Regulations, or GDPR, in Europe, and the California Consumer Privacy Act, or CCPA. What are the problems with expansive top-down regulatory regimes such as this?
With the GDPR, we have already seen that there are fewer data actors in Europe. You already had a very top-down regulatory regime, but smaller players have had to exit the market in some cases because of the cost of compliance, and therefore you may not be getting innovative solutions that could be more protective, and you're not seeing the kind of competition that we would like to see when it comes to that can provide better security.
Thank you. Mr. Chairman, I have here 3 letters addressed to our subcommittee concerning issues before us today. The first is from the R Street Institute, a nonpartisan think tank. The second is from the National Association of Federally Insured Credit Unions. And the third is from the Credit Union National Association. I ask unanimous consent that these letters be inserted in the record.
Without objection, so entered.
Thank you. I yield back my time.
Thank you, Mrs. Miller. Ms. Presley, you're on the clock for 5 minutes.
Thank you, Mr. Chair, and I want to thank all of our witnesses for joining us today. It is clear from your testimony that consumer reporting agencies occupy a very unique space. They deal in consumer data, but they do not deal with consumers. Their customers are businesses. Their products are the data they gather about you and me and millions of other Americans. They have the power to affect people's lives in critical ways. They provide the reports that determine everything, from whether you can get a loan to whether you can obtain housing or even employment. And yet they put people at risk when they lack adequate data protection safeguards, like we saw with the Equifax breach, which impacted nearly 48 million consumers in 2017. In fact, last month in a hearing held by the Financial Services Committee, which I'm a member of, I asked the CEO of Equifax whether anyone on their leadership team was held accountable for this data breach. His response was, and I quote, "There was plenty of accountability. The entire leadership team in 2017 did not receive a bonus," unquote. This, as I'm sure you would agree, is an insult to the millions of consumers that were affected by the breach and continue to this day to struggle to bounce back after having their data compromised. So I want to touch on what options, if at all, consumers have in this market. You spoke to some of this, all of you, in your testimony, if you could elaborate, where clearly there is no accountability for CRAs when breaches like this happen. Director Clements, in the GAO report, you explained that consumers lack choices in the consumer reporting market. So if we could unpack that, just for the record, consumers are not voluntarily providing their data to CRAs. Businesses are not voluntarily providing their data to CRAs. Businesses are doing that, correct?
The consumer data ultimately is an input to the process, so you're correct.
Okay. And so consumers are never actively providing consent for our data to be provided to CRAs. Again, given your testimony, that's an accurate characterization, correct?
Correct.
Okay. So if a constituent of mine is dissatisfied with Equifax's data protection practices, can he or she choose to remove their data to the competitors and only have Experian and TransUnion maintain their files?
No.
Okay. Well, what about leaving the consumer reporting market entirely? Could someone force the CRAs to delete their records?
The CFPB has told us that consumers have no legal right to remove their data from a CRA.
Okay. And so consumers do not voluntarily opt in to have their information shared to the CRAs, nor can they opt out. Instead, businesses are providing it, whether consumers want them to or not. And once the CRAs have the information, consumers are essentially locked out, correct?
That's correct.
Okay. Okay, Mr. Litt. Okay, a couple more minutes left. Most other private businesses cannot avoid consumers the way CRAs can. Most businesses have to try to keep consumers happy or risk losing them to their competitors. But CRAs are different. Can consumers make decisions with their dollars that would incentivize CRAs to ensure that they protect sensitive data about their customers?
No, they have no say in the matter.
Without the pressure of market forces, is data security at CRAs a necessary area for government regulation?
Absolutely.
Back to you, Director Clements. The GAO report indicates that CFPB has identified credit reporting as a higher risk market for consumer harm. Can you explain why it made that determination?
I can't explain CFPB's logic. Our logic, or what we think CRA is a high-risk area. One is it serves an essential function in the marketplace and financial services industry. Second would be the large amount of sensitive information that is contained there. And then third, the fact that consumers have limited choice in this marketplace.
Thank you. So without consumer choice, CRAs lack the same market pressures as typical businesses to adequately protect consumer data. That is a market failure, and it reinforces the need for strong government rules to help ensure sufficient consumer data protection at CRAs. I thank you all for your testimony here today, your expert testimony, and look forward to working with all of my colleagues so that we can provide ample oversight and accountability for these CRAs, since clearly they can't be trusted to do that themselves. Thank you.
Thank you, Thank you, Ms. Presley. Now, Mr. Grothman, you have 5 minutes.
Very good. I'll start off with a question for Mr. Smith. Am I correct in saying that the FTC has authority to take enforcement action against credit reporting agencies that don't properly protect the consumer's personally identifiable information, or that act in an unfair, deceptive manner when it comes to consumers' personal data?
Yes, we have authority under the Fair Credit. We enforce the Fair Credit Reporting Act against consumer reporting agencies. We enforce our safeguards rule against consumer reporting agencies, and as you noted, we enforce we have general authority to prohibit unfair and deceptive practices.
And you brought over 60 cases against companies since 2002?
For data security violations,
Correct.
yes.
Correct. And you brought 30 cases against companies for violating the Gramm-Leach-Bliley Act, including the safeguards rule?
That sounds okay to me. That sounds right.
What's the process for bringing one of these cases?
Well, it might be, generally we would learn of the case through a variety of means. It might be press reports, it might be consumer complaints, it might be tips or reports from other agencies. And then we will usually issue a civil investigative demand, which is an administrative subpoena to the company, and conduct the investigation through the normal course.
As a practical matter, if my data has been breached, how do I find out about it?
You will generally find out about it because the company notifies you, because there are, in every state, there are laws that require companies where there is an unauthorized access or acquisition of data, requires the company that's been breached to send the affected consumers a notice.
Okay. But as a practical matter, that's if the company identifies or contacts me themselves. What bad thing would happen to me that I would find out about it? Or how often when there's a breach do bad things happen?
So it's very difficult for us to say how often when there's a breach do bad things happen. Every once in a while, we can actually tie breached information to subsequent fraud against consumers. One example of that is when there was, I think it was the Yahoo page that had usernames and passwords that consumers used at other sites. And so there was some ability to link, but generally the proximate causation of compromised data to any eventual consumer harm, that can be a difficult thing to show.
Okay. How many people do you think had bad things happen because of this? Do you have any idea?
Because of
the breaches.
Of breaches generally, or of the Equifax breach?
Well, both.
Specifically. So we spend a lot of time studying identity theft in the economy generally, and we know that there's a sort of a background level of identity theft. In any given year, a certain number of us will be subject to identity fraud, and the reasons for that may be difficult to discern. What we are looking at when we try to look at sort of gross aggregate levels of harm to consumers is, following a big breach like Equifax, is there any change to that background level of identity theft? My understanding, and again, I'm not commenting on any particular investigation that we have in front of us, but my understanding is that Equifax has claimed that there hasn't been any increase generally in the gross level of identity theft. But that just could mean that the information hasn't yet been used.
Do we know any hard numbers as far as in the Equifax breach? How many people had a bad thing happen to them? Not get a letter in the mail saying that, you know, your identity has been breached, but a bad thing was done with that information.
Right. I think that's going to be very difficult for anyone to show. I mean, the bad things that we would be thinking about would be someone opening a credit card in your name, for example. That's the causation, the causal link between the Equifax breach and that new account opening in your name.
You really don't know. They don't keep track of that. Nobody knows. Okay. Ms. Huddleston, you're a scholar focusing at the intersection of technology and the law. Do you think the FTC's approach to ensuring data privacy and security has been effective so far?
The good thing about the FTC's approach to data privacy and security is that it has been flexible to move with the technology. The concern is that because it's often done through consent decrees, it doesn't necessarily provide regulated entities with the knowledge of what's constantly expected of them. At the same time, our court system and the common law may be able to provide redress for those consumers who do have the measurable harm you were mentioning in your earlier question.
Okay. I can give one more question. This is kind of a little bit off the topic, but just in general, I always think when these agencies, the major concern is that there are flaws in their information in which you could be harmed and you don't even know you're being harmed. Do you think we're doing an adequate job of policing that potential problem? In other words, if there are two Glenn Grothmans in the world and the other guy's a spendthrift, to what degree are we catching that sort of thing, or to what degree are people's credit score being harmed unfairly? Or do we catch that sort of thing?
So I can start on that. I think that mistaken identity is a big problem in the credit reporting system. We want to make sure. So my name is Andrew Smith. There are tens of thousands of Andrew Smiths. How do I make sure that a bad Andrew Smith doesn't get mixed up with me? Or how do I make sure that his information doesn't wind up in my file? Those are challenging issues that they're apart from the data security issues, right? But they have to do with data quality.
That's right. It's not exactly on point, but I think probably insofar as you worry about these agencies, well, I guess we'll be done. We'll go on. My chairman has given me the hook. That's okay.
Yeah. Well, I will say that we brought a case just a couple of months ago for this very accuracy issue, where there was information about a bad person showing up in your file. It was against a company called RealPage, and we obtained a $3 million penalty under the Fair Credit Reporting Act. So there are laws against it, and they are enforced.
Thank you.
Very good. Thank you. Ms. Tlaib, you have 5 minutes.
Thank you. I want to thank all of our witnesses today for joining us. Director Clements, I would like to discuss the Consumer Financial Protection Bureau's role in ensuring data security at consumer reporting agencies. In Michigan alone, close to 4.6 million consumers were impacted by Equifax's unprecedented data breach. My constituents, of course, don't have the luxury of constant credit monitoring, so it's imperative that we remain diligent in our oversight of these credit reporting agencies, especially now that they're using credit scoring and reports for car insurance and other elements of people directly impacting people's quality of life. How many CRAs fall within CFPB's larger participant supervisor power?
CFPB has told us it's tracking between 10 and 15 of those companies.
And the GAO report, the Government Accountability Office report, recommends that CFPB leverage additional resources of information to make sure it's tracking all CRAs that may qualify. Why?
CFPB told us that it was unsure whether that was the exact number of companies that met its threshold of $7 million of annual receipts.
Yeah.
So there could be a few additional companies.
Has CFPB indicated a willingness to do that?
CFPB has mentioned a willingness to leverage other data sources.
To fulfill its mission, it's important that CFPB knows all of the CRAs that falls within its jurisdiction. So CFPB is empowered to conduct supervisor examinations of CRAs. After the Equifax breach, the GOA report indicated that CFPB even developed internal guidelines for examining data security. Did CFPB actually conduct any examinations of data security at CRAs?
Our understanding is that following the Equifax breach, that CFPB has conducted multiple targeted data security exams at CRAs. What it was not doing was incorporating that type of information prior to the Equifax breach. So it was not looking at data security prior to the breach.
And the GAO report indicated that CFPB has the authority to conduct these data security examinations of CRAs, these acronyms in DC, I can't believe it, pursuant to its general authority to assess compliance with federal consumer protection laws such as Dodd-Frank Act, prohibiting any unfair, deceptive, and abusive acts and practice. Yet the GAO report indicated that CFPB has not committed to continuing considering data security risks and selecting examinations going forward. Is that correct?
That's correct.
GAO's report also said, in light of the Equifax breach, as well as CFPB's acknowledgement of the CRA market as a higher risk market for consumers, it is important for CFPB to routinely consider factors that could inform the extent of CRA data security risks, such as the number of consumers that could be affected by a data security incident and nature of potential harm resulting from the loss of exposure of information. So this GAO report recommends continuing to prioritize the risk of data breach in selecting examination topics. Can you explain why that is particularly important?
Certainly. In the past, what CFPB was looking at when it was doing the supervision was focusing on consumer complaints, past exam filings, and public filings. So they ended up looking at issues such as the accuracy of the data and the dispute resolution process. And we don't dispute at all that those are important. But what it wasn't factoring in was the risk to consumer information that a breach might happen. And that's what we're recommending is just within the prioritization process. Doesn't mean that on every instance they would need to do that type of exam, but at least you're considering it when you're making a decision of, I'm going to do an exam of a CRA, what factors should I look at in that assessment?
Thank you. The report also noted that other institutions that hold sensitive consumer data, like insured depository institutions, are already subject to technology examinations, which include cybersecurity component. Wouldn't we want the same kind of supervision on CRAs as we have for banks?
I think our findings really get to 2 points. On the one hand is factoring in on those examinations that CFPB is conducting data security. And then the other recommendation we're making to FTC is to have some predictability and a penalty available should the firm not meet the requirements, in that case, of Gramm-Leach-Bliley. So it's a really, our findings were a combination of both examinations and the penalty.
Okay, thank you so much. I yield my time.
Thank you, Ms. Tlaib. Ms. Hill, you're up for 5 minutes.
Thank you, Mr. Chairman, and thank you all for being here. I know you've touched on the answers to some of these, but I want to get clarification on a few things and just get this for the record. Director Clements, I would like your help in understanding the scope of the credit reporting market. People may be familiar with the big three, Equifax, Experian, and TransUnion, but I was struck by the following statement in the GAO report, which states, and I quote, according to the CFPB, the consumer market reporting market comprises more than 400 companies, and these companies issue 3 billion reports and make more than 36 billion updates to consumer files each year. So beyond the big three, there are hundreds of these companies out there, each holding our sensitive information. Is that correct?
That is our understanding from CFPB, yes.
Great. And these CRAs have subsidiaries that conduct marketing activities. The GAO report indicates that CRAs are able to share information with their affiliates for marketing purposes as long as they disclose that and give consumers an option to opt out. Is that right?
It depends on the relationship that the individual would have with the credit reporting agency. If I have a relationship with the credit reporting agency, for example, if I'm buying a credit monitoring service, the credit reporting agency can then share that information with its other affiliates. But again, it needs to provide notice, an opt-out option, and then I, as the consumer, would have to not opt out. But if that's the case, there can be sharing with other affiliates within the CRA.
What would another case be where they wouldn't have the sharing opportunity?
If I'm not a consumer of, or if I'm not a customer of the CRA, then I don't have a customer relationship, and then the rules are slightly different.
And different how?
There would be less sharing opportunities in that case because, again, I'm not a customer in that instance.
Okay. So in addition to consumers being concerned about their information being breached through the back door, they also have to worry about it leaving through the front door on its way to the marketing arms of the CRA. Is that right?
Again, it depends upon the customer relationship and whether the customer chooses the opt-in or opt-out of the sharing.
I mean, I feel like it's not usually, even when you quote-unquote opt-in or opt-out, it's not a very transparent process. I think that it's usually you check a box as you're trying to hurriedly fill out a form to get something that you need. But is that what you're referring to?
I think in terms of those specifics, we didn't get into that. I'd probably defer to FTC or CFPB in terms of the ease of a customer opting in or opting out.
Okay. Director Smith, FTC published a helpful guidance to companies about complying with the safeguards rule that you make available online. It's entitled Financial Institution and Customer Information, Complying with the Safeguards Rule. In the How to Comply section, it states, and I quote, one of the early steps companies should take is to determine what information they are collecting and storing and whether they have a business need to do so. You can reduce the risks to customer information if you know what you have and keep only what you need. Director Smith, it does not appear that CRAs were heeding that advice prior to the Equifax breach. Since then, have you seen any indication that CRAs have downsized the amount of data they are keeping about us?
So we don't have any information about them downsizing the information. I would say that that guidance is more sort of directed at companies being mindful of the information that they have, inventorying it, and making sure that they still have a need for it. I suspect that if we were to ask the CRAs, they would say this is information that we need.
Okay. Do you know if Equifax or any of the other CRAs have reduced their use of Social Security numbers?
Not to my knowledge, no.
Okay. Mr. Litt, Social Security numbers are used as both identifiers and authenticators. Can you please explain the difference?
Sure. An identifier basically matches your file, matches you to your file, and an authenticator proves who you say you are. So you can think of an identifier as a username and an authenticator as a password.
Okay, so in theory, an authenticator should be something secret that only you can provide. Is that right?
That's right.
So after Equifax exposed so many Social Security numbers, they're no longer a secret. Should CRAs stop using them as authenticators?
Yeah, they should stop using them, at least as part of their authentication process.
Does the continued use of Social Security numbers as authenticators help fuel identity theft?
Yeah, they do, especially with the Equifax breach, because that's more than half the adult population, and you can't change them.
And do you know if Equifax or the other CRAs have stopped using Social Security numbers in the authentication process?
I'm not aware of that.
So at this point, Social Security numbers are widely known, and I would like to see companies acting accordingly and to stop using them as authenticators. Thank you so much.
Thank you, Ms. Hill. With unanimous consent, I enter the following statements into the record. I have a letter from the Conference of State Bank Supervisors and a letter from the Electronic Privacy Information Center. Without objection, so entered. I'd like to thank our witnesses for their testimony today. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their responses. I ask our witnesses to please respond as promptly as you are able at that time. Thank you so much again. This meeting is adjourned.